This program is proudly brought to you by Telecom Limited and Daytech.
Welcome back. You're watching Infocus. Now, Justice Kerry, given the transnational nature of many disputes, for example, environmental degradation, territorial disputes, refugee crisis, and international trade disputes, how practical is mediation in this context?
One of the fascinating things about mediation is that it is the persons who are part of the dispute who are coming together to honestly assess their realities and look at ways to find solutions. With transnational issues, you're dealing with multiple jurisdictions. So let's say there's a climate change litigation issue that involves Papua New Guinea, Singapore, Hong Kong, and Australia. And you're trying to determine where should we have this matter litigated, which venue, forum, which court, which country. When you have a mediation agreement or an agreement or commitment rather, sorry, to mediate, and you have the parties coming together regardless of the jurisdiction they're in, they have agreed to come together to identify how they can have a solution that makes sense. It is able to get over that hurdle of where you have to go through litigation to one, look at the contractual arrangement or the agreement, or look at where is the location for the governing law of the contract, and you get past that to parties saying, you know what, we want to solve this problem without going through a protracted legal fight in court. So I think the aspect of being able to have a mediation solution in jurisdictions like Papua New Guinea, which are well regulated, have an excellent judiciary in terms of the capacity to deal with mediation issues, and you have a large number of qualified Papua New Guinean mediators who are welcoming and interested in mediating international issues that comprise transnational types of problems. I think mediation becomes very applicable to this kind of problem.
Now, to what extent is mediation effective within the PNG judicial system?
So as I mentioned earlier, in the Commonwealth, and PNG is a part of the Commonwealth, 60% of litigation issues are being put into mediation. Our Chief Justice, Sir Gibbs Salika, in his pronouncements at the opening of the legal year, has said that about 60% of matters should be going into mediation, and that is happening. So we're putting a lot of matters that come before the courts in litigation, and we're talking civil, not criminal. So civil matters, litigation, 60% are going into mediation. Out of that 60%, more than half of that 60% are being solved with solutions where they come back to the courts for consent to be agreed by the court. A consent order is submitted, the judge simply signs off, and the parties walk away with a win-win. So it is happening in PNG. There are a lot of people who are getting qualified as mediators, Papua New Guineans, who are now participating in mediations, whether it's landowner issues, such as in the Highlands region with land conflict, or whether it's climate change, litigation issues, or even as, and this is not simple, but wills and disputes between families who are fighting over certain aspects. Things like that are headed to mediation, and we're seeing results.
In terms of training, will mediation be conducted by specifically lawyers or an individual?
So you don't have to be a lawyer to be a mediator. To be a mediator in Papua New Guinea, you simply do the 38-hour course, basic mediation skills training, which is offered by the Alternative Dispute Resolution Division of PNG Judiciary in consultation with PNG CJ. After you do the 38 hours of mediation course, once you're successful in completing the assessment, then you become a provisionally accredited mediator. After doing 5 co-mediations with a fully accredited mediator, then you're qualified as a fully accredited mediator, and then you can conduct mediations as they are assigned to you by the court in Papua New Guinea. There are a lot of opportunities for anybody who is interested. Once you have a willing spirit, a good heart, and focused on helping the people who have disputes through mediation, you can complete the course and be qualified. I repeat, you don't have to be a lawyer to become a mediator in Papua New Guinea, or anywhere else in the world for that matter.
Are there examples of states or jurisdictions around the Asia-Pacific which have excellent mediation avenues within their legal processes which Papua New Guinea can draw from?
Well, we look through Asia-Pacific, in particular Asia. You think of Singapore, you look at Hong Kong. Throughout the Pacific, you have small island developing states, Tonga, Samoa, which has mediation at the lay judicial level, so non-legal people. in PNG, the Center for Judicial Excellence has actually conducted training. So we've trained mediators in Samoa, we've trained mediators in Kiribati, we've trained mediators in Solomon Islands. So we're talking about Pacific Island people coming to PNG to be trained as mediators by Papua New Guinean qualified mediators. The other thing I should say that is when you do the course in PNG to be an accredited mediator, you are automatically by the qualification level, once you do the requirement of registering in Australia, are automatically eligible for registration. So all of us who are mediators in Papua New Guinea, either provisionally accredited or fully accredited, are most likely accredited mediators in Australia. So that is the quality of the mediators that we have in Papua New Guinea, people who are internationally recognized throughout the region.
Thank you, Justice Kerry. We now go for a quick break. Join us on the other side for more discussions.
I think on the balance of probabilities, it's affordable for both small and medium-sized businesses and larger businesses. Larger businesses have deeper pockets and they have the ability to fund litigation at a much stronger and robust way than small and medium-sized businesses. With a small business, if you go into litigation and you're fighting in court, that means spending a lot of money for lawyers to go to court, go to trial, the process of getting all of the paperwork in that needs to be filed for submissions. When you assess how much you spend doing that, if you go into mediation and spend a couple of days with a mediator and the other party, you may get a solution for a much lower cost. And so it's very much relevant to small and medium enterprise businesses to explore mediation rather than fighting in court and spending a lot of money on legal fees. You can spend, I've seen legal fees in some jurisdictions outside of PNG when I practiced as a lawyer years ago, up to 4 or 5 million kina for one matter that hadn't even reached court yet. That's very costly. 4 or 5 million kina, a small, medium-sized business can't afford that. Therefore, it is beneficial to them to consider mediation as a solution when they have disputes. For example, an employee leaves the company or is terminated. Instead of going through the wrongful and unfair dismissal litigation, go to mediation, get the matter addressed and resolved so both parties walk away with a good solution. So the mediation process, as I mentioned, deals with solutions that come up from the parties. It doesn't come from the mediator. And so state, whether it's private business, whether it's transnational entities looking to get solutions that can be enforced through the courts at a much lower cost, mediation is the appropriate manner. And the key issue is for parties to come with good faith. When people come to the table to address their problems in good faith, you probably end up with good solutions and good outcomes. When they come to the table with an attitude of expecting something that's not realistic, then they're not likely to get the outcome that they want. So that's something that mediation facilitates for parties who come to the table. Well, when policymakers have discussions, whether it's in the arena that they work in, that is Parliament, or whether it's talking to their constituents, explaining to them and explaining to ordinary people that instead of taking your disputes in a manner that's not compliant with the law, explore mediation. Find ways to have meaningful dialogue to find solutions. Oftentimes, the conflicts that we have throughout the world results with miscommunication, people not speaking to each other. Mediation encourages people to talk to each other, and policymakers can encourage people talk to each other to find solutions. It will actually make it much easier and more cost effective. So if you are in Mount Hagen and you can't afford to physically come down to Waigani where a company and you have a dispute, using virtual technology like Zoom or MS Teams, you can go to the courthouse where we have a mediation center and the mediation can be conducted there, where the mediator could be physically there with you in Hagen, or can be physically here in Moresby. Or if it's somebody in Kokopo and somebody in Tari, they can be in different locations, but physically different locations, but virtually able to communicate with the mediator based in Moresby, where all parties are able to speak to each other. That's what technology has done for us in 2024. I think that mediation is something that has been around for many years in different forms, but the proper procedures and protocols that are in place for globally recognized mediated solutions are very relevant to the blue and the green economies, and will open up avenues for full discussions where people can have sensible discussions in finding solutions. I keep talking about solutions, discussions when I think about mediation, because it is something that will open doors that otherwise were not open before, even 25, 30 years ago. With the emergence of the different economies, and we're talking about carbon credits and how countries that produce less emissions are able to benefit, mediation will help to be able to get the solutions for countries like PNG, who don't contribute anywhere near to the damage of the environment as other countries, but should be benefiting for their net positive contribution to improving climate. That's what mediation can assist, where you have these kinds of discussions happening transnationally. It will open up doors that don't historically have not existed. So the 10th Asia-Pacific Mediation Forum Conference is being held in Papua New Guinea in August 19 to 21. The last one was held in Korea. And the president of the Asia-Pacific Mediation Forum, Professor Dale Bagshaw, will be here, along with a lot of judges, lawyers, mediators from Asia-Pacific. We have our Deputy Chief Justice, Ambing Kandakazi, who is the Deputy President of the Asia-Pacific Mediation Forum. That's a tremendous feat for PNG and the Pacific, that we have a Pacific Islander who is the Deputy or Vice President, and is probably going to be president at the end of this conference, the first time in the history of the Pacific. These are opportunities to engage with mediators from around the Pacific and Asia, to have discussions on regional developments that we can explore in applications in PNG, and improve in climate change litigation to apply mediation. We expect about 500 participants. There may be more. The NEC has recognized this as a nationally significant event, and therefore the government is supporting the Asia-Pacific Mediation Forum Conference to ensure success, but also to benefit all of the Papua New Guineans who will be attending, to improve the quality of their practice as mediators. This is an emerging profession. I encourage every Papua New Guinean who wants to see this country better, explore mediation as a career. It really is a career option for young Papua New Guineans coming up. When you look at the amount of conflicts that we have in PNG and throughout the Pacific and throughout the world, PNG is really well placed to address those kinds of problems through mediation. And this conference will allow discussions from all sectors of our society to be able to explore mediation and application in PNG. Thank you for having me.